Good morning. I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow Commissioner Susan Duffy and Commissioner Andrew French. At this time, I'm convening a hearing in the unanimous settlement agreement in docket number 21-ATMG-333-GIG that pertains to the Atmos Energy Corporation financial plan in the matter of the investigation into Atmos Energy Corporation regarding the February 2021 winter weather events as contemplated by docket number 21-GIMX-303-MIS. Due to the pandemic and for the convenience of the parties and the commission, we are conducting this hearing by Zoom and broadcasting to the public on YouTube. Please bear with us if you should experience any technical glitches. This morning, I want to first turn to the entries of appearance, and we'll begin with Atmos Energy Corporation.
Good morning, Commission. James G. Flaherty, Ottawa, Kansas, appearing on behalf of Atmos Energy Corporation.
Thank you, and good morning, Jim. The Office of the Kansas Attorney General.
Good morning. Melanie Jack, Assistant Attorney General, appears on behalf of the Attorney General's office.
Thank you, and good morning to you, Melanie. The Citizens Utility Ratepayer Board.
Yes, this is Todd Love, appearing on behalf of the Citizens Utility Ratepayer Board, also known as CURB.
Thank you, and good morning to you, Todd. And the KCC staff.
I was expecting Walker Hendricks. My apologies. Terry Pemberton on behalf of commission staff, and Walker looks like he dropped off my screen, so hopefully he'll be back shortly.
Okay, well, thank you, Terry. At this time, does the staff have any recommendation regarding notice?
I do. If you give me just a minute.
Sure.
Walker's joining.
Terry, it looks like Walker's rejoining us.
Okay, I can go ahead and give note. Walker, do you want to give notice on recommendation on notice? You're on mute.
Walker, you're on mute.
I'll go ahead and give the recommendation.
Here, I'm okay.
Okay.
I just I've basically, disconnected myself and reconnected myself, so I hit something that I shouldn't have hit. Sorry about that. Anyway, notice is proper. The commission modified the procedural schedule on February 17th, and we did have a pre-hearing conference on February 25th, and the commission has accommodated the schedule to permit this hearing on the settlement agreement today. And we want to thank the commission for its cooperation and obliging the party's ability to be here today. Thank you.
Thank you. Are there any objections to notice? Hearing none, I find that notice is proper. The commission has jurisdiction over this proceeding at this time and place. Before we turn to preliminary matters, let's consider a few matters incidental to conducting these hearings via Zoom, just as a reminder to everyone. First, if any party encounters any technical issue today, I would certainly encourage you to ask to go off the record so that we can resolve the technical issue off the record. Second, witnesses participating by Zoom are asked to keep their microphones off when they are not scheduled to speak. Third, if the commission needs to deliberate, we will be going off the record, entering a Zoom breakout room where you can't see us or hear us, and then subsequently returning. And fourth, since we are participating at a distance, please be careful to identify exactly what you are referring to when discussing pre-filed testimony or exhibits. We have copies of all of those on hand, so we should be able to follow along if you'll just help us identify those matters. I understand that Atmos wishes to admit pre-filed testimony into the record. Mr. Flaherty?
Yes, thank you, Your Honor. Atmos Energy would request that the pre-filed direct testimony and exhibits that Atmos Energy filed in support of its financial plan on September 14th, 2021, and the revised exhibit RL3 that was filed on February 25th, 2022, be referred into this record.
Very well. Are there any objections? Without objections, all of that is admitted. Are there any other preliminary matters we need to address by any of the parties? Very well. Regarding the procedures for this hearing, I understand that the parties, of course, are going to be making opening statements. Atmos will go first, followed in order by Curb and then the KCC staff. After the opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. I understand that at the pre-hearing conferences, the parties indicated that they will not be making closing statements. So with that behind us here, let's turn to the opening statements, and we will begin with Atmos Energy Corporation, Jim Flaherty.
Thank you, Your Honor. And for the court reporter, this is James G. Flaherty. And Michelle has been gracious enough to run the slide presentation that I provided to the commission and the parties that I'm prepared to use in my opening statement this morning. So Michelle, if you can put that up on your screen, that would be great. Thank you. So good morning. The parties are here to present to the commission for its review and approval a unanimous settlement agreement on Atmos Energy's plan to minimize the financial impact to its sales customers relating to the extraordinary cost incurred during Storm Uri back in February of 2021. Michelle, can you turn to slide 2, please? So as you know, Atmos Energy serves approximately 135,000 customers in 110 communities located in 32 counties in Kansas. As you can see from the map on the screen, which is attached to Mr. Armstrong's testimony, in this case as an exhibit, the Kansas communities served by Atmos Energy are spread throughout the state. In the Kansas City area, Atmos Energy serves Olathe, Bonner Springs, DeSoto, and portions of Kansas City, Overland Park, Shawnee, Lenexa, and Lawrence. In Southeast Kansas, the company serves Independence, Coffeyville, Yates Center, and other smaller communities. In Central Kansas, Atmos Energy serves Council Grove and Harrington and a few other small towns in that area. In South Central and Northwest Kansas, the company serves Anthony and South Haven near Wichita and Ness City in Northwest Kansas. And finally, in Southwest Kansas, the company serves Ulysses and Johnson City and a few other smaller towns in Southwest Kansas. As provided in the exhibits attached to Mr. Malter's direct testimony, Atmos Energy purchases gas from suppliers off of a number of interstate and intrastate pipelines and contracts for gas storage services off a number of those pipelines. Atmos Energy also operates its own gas storage facilities in Southeast Kansas. Michelle, if you can turn to slide 3, please. As you know, the commission asked Atmos Energy, along with the other utilities impacted by Storm Uri, to file a plan to recover the deferred extraordinary gas cost and other extraordinary cost in a way that would minimize the financial impact to customers on the utility. Atmos Energy filed its original financial plan with the Commission on September 14th, 2021. Atmos Energy in that plan explained that under its proposed plan, it would take advantage of the 2021 Kansas Legislature's Kansas Utility Financing and Securitization Act. And if the plan was approved by the Commission, it would apply for a financing order in a separate docket. And if that financing order was approved in that separate docket, it would allow Atmos Energy to recover what the Act refers to and what we refer to in this case as qualified extraordinary costs through the issuance of securitized utility tariff bonds. Atmos Energy's plan identified and quantified the extraordinary cost, and those are contained in Ms. O'Connor's direct testimony at page 4. To be financed, that included about $87.9 million in deferred gas costs, excluding carrying cost. Atmos Energy's plan also included recovery of carrying cost on the deferred gas cost, and pursuant to the Commission's February 15th, 2021 order in the 21303 docket, Atmos Energy used its current weighted average cost of capital to calculate the carrying charges on the deferred amount for the period between when the costs were incurred and when the securitization bonds would be issued, which was estimated to be $9.4 million. Atmos Energy allocated the deferred cost and carrying charges to customer classes based upon each class's February 2021 usage. Atmos Energy's plan called for using the reconciliation process that's set forth in the Act to credit customers for any net penalty amounts recovered after the bonds were issued and any relief obtained and received by Atmos Energy relating to actions taken by the FERC and the Kansas Attorney General's Office regarding profit disgorgement, civil suit relief, and market manipulation findings. Michelle, if you can turn to slide 4, please. In support of Atmos Energy's financial plan, it submitted the testimony and exhibits of those persons listed on slide 4. The testimony and exhibits have been referred into the record this morning by the Commission and provide substantial, competent, factual, and expert testimony that supports the unanimous settlement on the financial plan that is being presented to the Commission today. Slide 5, please. Slide 5 shows the estimated monthly impact to residential and small commercial customers under a 10-year and 15-year securitization proposal using the qualified extraordinary cost and the reduced carrying charge rate contained in the settlement. These monthly impact numbers are less than the numbers contained in Ms. O'Connor's direct testimony because Atmos Energy has agreed to reduce the carrying charge amount from $9.4 million to $2.2 million, or a reduction of $7.2 million, and because of the lower payment to KGS that was approved by the Commission yesterday. By using securitized utility tariff bonds under the Act that was approved by the legislature with a 10-year or 15-year term, Atmos Energy should be able to reduce the impact to a residential customer down to between $3.75 per month to $5.11 per month under the settlement. That compares to $47.70 per month had Atmos Energy attempted to recover the cost over a 12-month period, and that's outlined in Ms. O'Connor's direct testimony at table 4, page 17. Slide 6, please. If Atmos Energy were to use a traditional rate-making approach to recover the deferred cost and amortize those costs over 3 years at Atmos Energy's weighted average cost of capital, the impact to a residential customer would be $16.84 per month after accounting for the lower amount Atmos Energy owes under the final settlement with KGS that was approved yesterday by the commission. What might be of interest to the commission and to our audience is that if the settlement in this case is approved, the total dollar impact for a residential customer of Atmos Energy should be very close to the total dollar impact for a residential customer of the other two major gas utilities in Kansas, which is a little over $600 in total. As mentioned in those other cases by Mr. Nickel and the commissioners, while that is a large amount to pay and while it'll have an impact on customers, we have to compare that to the cost of a life lost or the cost of property damage due to frozen and broken water pipes if customers were without heat. Slide 7, please. Pursuant to the procedural schedule issued by the commission in this docket, all of the parties conducted and participated in a technical and settlement conference that resulted in several virtual meetings and the settlement that was filed with the commission on February 9th, 2022. The main terms of the settlement are set forth in these last two slides, slides 7 and 8. The settlement on the financial plan, it's important to point out, is supported by all the parties in this docket. The settlement states that the $102.5 million in qualified extraordinary costs that are set forth in Appendix A to the settlement were prudently incurred and subject to those costs being updated, trued up and verified in the separate docket regarding the financing order, shall be financed by Atmos Energy applying for the issuance of securitized utility tariff bonds under the Act. The settlement also allows for Atmos Energy to recover carrying charges at a rate of 2% on the qualified extraordinary cost from the date those costs were incurred until the bonds are issued. Lowering the carrying charge rate from Atmos Energy's weighted average cost of capital to 2% reduces the carrying charges from $9.4 million to $2.2 million. Issues relating to such things as the term of the bonds and whether the securitized utility tariff charge will be recovered from customers using a fixed monthly charge or a volumetric charge have been deferred to the separate docket regarding the financing order that will be filed if this settlement is approved by the commission, and those issues will be decided in that separate docket. In the event Atmos Energy receives any funds as a result of profit disgorgement, civil suit relief, or market manipulation due to state and federal investigations, those funds will be passed on to customers through the company's PGA, ACA on an annual basis. Slide 8, please. Provided that such is allowed under the Act, the securitized utility tariff charge will not be charged to transportation customers because they are not considered retail customers under the Act. Atmos Energy has also agreed to discuss with staff and CURB the programs that it has in other states to assist low-income customers to determine if those programs might work in Kansas. Atmos Energy's sales customers who intend on becoming Atmos Energy transportation customers shall be required under this settlement to pay a conversion or settlement fee based on a net present value of expected charges that the customer would have paid as a sales customer. Let me close by indicating that Atmos Energy believes that the terms of the settlement on the financial plan are reasonable because they minimize the financial impact on our sales customers while allowing Atmos Energy the opportunity to return to credit metrics to pre-winter storm Uri levels in a reasonable period. Atmos Energy will be presenting Ms. O'Connor this morning to testify in support of the unanimous settlement. She is the Vice President of Rates and Regulatory Affairs for the Colorado-Kansas Division of Atmos Energy, and this is her first opportunity to appear before this commission on behalf of Atmos Energy. Atmos Energy would request that the commission approve the settlement on its financial plan. Thank you.
Thank you very much, Jim. That was a very good overview. Next opening statement will be from the Citizens Utility Ratepayer Board, Todd Love. Todd, please.
Good morning, Commissioners. As you know, my name is Todd Love, and I'm an attorney with the Citizens Utility Ratepayer Board, commonly known as CURB. I'm here today to address the unanimous settlement agreement reached in Docket 21 ATMG 333 GIG. This is the Atmos Energy Winter Storm Uri financial docket. As we're all aware, Winter Storm Uri was an unprecedented weather event that left much of the country reeling and caused dramatic increases in the cost of natural gas. While no citizen of this state nor participants in this proceeding are pleased with the circumstances presented here, it is an unfortunate reality that customers will have to pay an increase in the utility bills to cover these unexpected and painful costs. All Kansas jurisdictional utilities, as well as non-jurisdictional utilities, were greatly affected by these increases. In this docket, we're concentrating on the events of Winter Storm Uri on Atmos Energy in Kansas. After much discussion and negotiation, the parties in this docket were able to reach a unanimous settlement agreement. While there are numerous aspects of the agreement, I will not restate them in specifics as they have just been addressed by Mr. Flaherty. CURB's rate analyst, Josh France, has filed testimony in support of the unanimous settlement agreement and has detailed why he believes it satisfies the Commissioner's 3 required elements for such an agreement. These being, is it supported by substantial competent evidence in the record as a whole? It will establish just and reasonable rates, and it is in the public interest. Mr. France also addresses some concerns regarding penalties imposed on Atmos by Kansas Gas and CURB's thoughts regarding these. Mr. France will be available for any questions the commissioners may have. Ultimately, CURB requests the commission to approve the unanimous settlement agreement signed by the parties. Thank you.
Our final opening statement will be on behalf of the KCC staff, Walker Hendricks. Walker, please. Is Walker here? Yes, he is. Walker, you're on mute.
Can you hear me now?
We can, thank you.
Sorry for that. May it please the commission. I'm Walker Hendricks and I'm appearing on behalf of the staff. I do want to acknowledge the hard work of the staff, not only in this docket, but in the other winter event dockets. They have analyzed a substantial amount of material and going over the information in this docket and in other cases. The staff will be presenting Justin Grady as its technical witness in this particular case, and Mr. Grady has filed both confidential and a public version of his testimony. Fortunately or unfortunately, I've been through several winter events. I can actually remember 1983 and some other years, and where the cold weather persisted and the gas charges were extremely high. And there was an enduring sort of situation, not only in those years, but in various dockets and at the legislature over time. However, this event was certainly an extraordinary event. And if you look at what happened in Texas and other situations throughout the country, you can see that the storm had a devastating effect. It extended over a 12-day period with freezing temperatures. There was excessive demand for natural gas. There were disruptive natural gas markets. There were equipment and gas well freeze-ups. There were force majeure clauses that were instituted, which canceled gas deliveries. And there were curtailments and interruptions. And really, this is the first time that I have seen actual curtailments implemented. You know, the companies do a good job owning and trying to get people to conserve, but curtailments were actually implemented in this particular docket. Obviously, the commission is mindful of the fact that the winter event led to an emergency disaster declaration. And this commission issued an emergency order, and it directed the utilities to take action to maintain natural gas service to ratepayers and to incur costs for both their operations and interconnected non-jurisdictional utilities. Extraordinary costs were to be deferred into a regulatory asset account, and utilities were to submit compliance reports and file a plan for cost recovery. Obviously, today we're here on the Atmos plan, and its financial plan was filed on September 14th, 2021. The plan was subject to extensive examination and discovery, and the parties, after some deliberation, were able to achieve a unanimous settlement on February 9th, 2022. Staff supports the settlement as a way to recover reasonably incurred gas costs and to minimize the financial impacts for customers. The agreed upon qualified extraordinary costs in this particular case are about $500,000, subject to possible minimum adjustments as described by Mr. Flaherty. The major component is the recovery of gas costs. Staff believes gas costs were reasonably incurred based on agreed upon strategies included in Atmos annual gas purchase and hedging plans. Those plans allow for first of the month baseload gas supply, hedging, storage, and incremental gas purchases. As noted by staff witness Justin Grady, Atmos during these winter months expanded its use of baseload and storage gas to minimize impacts. It interrupted transport customers and curtailed some customers. Because of high demand during the winter event, Atmos had to purchase incremental or swing gas in the open market to maintain supply beyond anticipated level. The swing gas, priced at extremely high prices, resulted in extraordinary gas costs. But fortunately, because of the Atmos purchase gas plan, those costs were modified to a considerable extent. Atmos gas costs were in line with other utilities and below many of the other prices established on other pipelines operating in the state. As such, the staff believes Atmos performed its responsibilities during the winter event, moderated customer impacts, and was reasonable in making gas purchases. The settlement is also reasonable as Atmos has agreed to lower the recovery of carrying costs at 2% to reflect short-term borrowing costs rather than its weighted cost of capital, which was initially highlighted by the commission as a possibility for collection. This will save customers approximately $7.21 million. And it's a considerable concession in this case. The settlement is also reasonable and in the public interest as it is conditioned on Atmos filing for approval of a financial order to securitize the recovery of extraordinary costs. As such, this is a two-tier process that anticipates the recovery of costs subject to financing and customer allocations in a new docket. Overall rate impacts from a securitized utility bond tariff will be in the neighborhood of $4 to $5 a month on a residential bill, depending on interest charges for the bonds to be issued and defraying the cost and the length of time that will be needed to retire the bonded indebtedness. Atmos anticipates requesting a fixed customer charge to defray the cost of issuing the bonds under the Utility Financing and Securitization Act that would not be adjustable during the maturity. But Mr. Flaherty has indicated that the commission will have that issue before it and may determine a volumetric approach if it so desires. Other alternatives, as Mr. Flaherty has indicated, were presented to show the reasonableness of this proposal and to minimize financial impacts. The PGA or a rider will be used to reconcile under or over recovery during the maturity of the bonds. The settlement also takes into account deferred tax liabilities and deferred tax assets, conversion fees for customers switching to transport, the application of any refund or cost recovery associated with high costs during the winter events, and consideration of possible low-income programs. Atmos has presented the terms of settlement in a slide presentation. There is only one other issue I would like to address, and that is the Kansas Gas Service penalty amounts that were determined in the Kansas Gas Service Docket 21-232. The penalties were approximately $9.5 million for 37,000 MMBTU. There was reasonable discussion of this issue during the settlement, and all parties came to the conclusion that the penalty amount should be recovered as part of the ordinary costs. Let me explain why. First of all, the amounts represent the cost of gas. There were no compounding charges. The overages were precipitated by a supplier on the KGS pipeline system issuing force majeure to Atmos. Ironically, the gas costs imposed by the penalty are lower than what Atmos would have paid under a gas contract with the supplier declining to provide service during that cold winter period. This was an extreme event that did not afford Atmos an alternative, and there is no evidence to suggest that Atmos was exploiting the situation. Throughout the deliberations in the winter event dockets, it is shown that there were underages and overages on nearly every system. Atmos also has marketers in penalty status that constrain the supply situation that can be taken into account. Atmos acted reasonably in getting customers to conserve during this period and was able to maintain service at nearly 100%. And if you basically compare that to what happened in Texas, Kansas was able to pretty much fully perform throughout this extreme period of time. In concluding, staff believes the settlement is reasonable and lawful. It is supported by all parties that had a full and fair opportunity to participate in negotiations. It is supported by substantial competent evidence. It is reasonable in light of the circumstances that gave rise to this event. And most importantly, it is in the public interest by moderating costs and minimizing customer impacts that will be ultimately determined in the financing docket to be opened. Approval of the settlement will give Atmos an opportunity to arrange financing under a plan that approves and minimizes the extraordinary costs associated with the event. The plan will allow Atmos to maintain an acceptable credit rating and permit financing to minimize the impact of the extraordinary costs that were incurred during this period. I want to thank the commission for allowing me to make this presentation. I'll stand for any questions that the commission might have. I look forward to being able to sponsor Justin Grady as a staff witness in this case. Thank you very much.
Thank you, Walker, for your opening statement. We will now turn to the commission's examination of the witnesses. Mr. Flaherty, would you please call your witness?
Yes, thank you, Your Honor. Atmos Energy would call Catherine O'Connor. And I think the court reporter needs to swear in.
Yes, please.
Kathleen, I need you to raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning. Can you please state your name and business address for the record?
Good morning. My name is Kathleen O'Connor. That's O-C-A-N-A-S. My business address is 2509 West 110th Terrace in Olathe, Kansas, 66062.
Who is your employer?
Atmos Energy Corporation.
What is your position with Atmos Energy?
I am the Vice President of Rates and Regulatory Affairs for our Colorado and Kansas divisions.
Did you pre-file testimony in support of the settlement that was filed in this case?
Yes.
And do you have any changes or corrections to your testimony?
No.
If I were to ask you the questions that appear in your testimony, would your answers be the same today?
Yes.
In your direct testimony, you included tables that showed the rate impact of Storm Uri on customers depending on how those costs relating to Storm Uri were recovered from customers, correct?
Correct.
And have you had the opportunity to revise those tables based upon the terms of the settlement, the reduction in carrying cost, and the lower amount owed to KGS under the settlement that was approved yesterday by the KCC?
Yes.
And are those revised tables included in the PowerPoint presentation that I just used in the opening statement at slides 5 and 6?
Yes, they are.
And were those revised tables prepared by you or under your direct supervision?
Yes.
Your Honor, I'd move for the admission of Ms. O'Connor's testimony in support of the settlement, as well as this is sort of a little unusual, but the admission of slides 5 and 6 into the record as Atmos Energy Exhibit 1.
Very well. Is there any objection? Without objection, all of these matters are admitted.
Thank you. And I would tender Ms. O'Connor for questions from the commissioners. Thank you.
Very well, thank you. We will begin with the examination by the commission with questions you may have. Commissioner Duffy, please.
Thank you, Chair Keen. Good morning, Ms. O'Connor.
Good morning.
So I note that you were promoted in July of 2021 to your current title and position as Vice President of Rate and Regulatory Affairs, correct?
That is correct.
So during the Storm Uri, what position were you in, and how were you related to the events with your company?
Sure. So when Winter Storm Uri hit, I was working out of our Mid-Tex, Atmos Energy Mid-Tex division. I was a rates and regulatory project manager at that time. So I was very involved in the events that occurred in Texas during that time.
Okay, but I noticed you did submit testimony in your present position in September, I believe, your direct testimony, correct?
That's correct.
Yes. Okay. So I've got a couple of questions, but I'm going to start here with the next chapter, the securitization chapter. So how, I believe I did read that in September, is that correct? You believe you'll be coming back to the commission?
Yes, very quickly, we will be coming back to the commission. If the commission approves this order, we have already started internally working on the next steps. And so as soon as we're able to finalize that, we will come back in for that.
Okay, very good. So there's a lot going on in the markets. So do you believe, I mean, that's essentially 6 months from now? So as the potential securitization is described in your testimony, do you believe that will still be relevant?
Yes, I mean, we're also seeing, the activity in the market as well. Again, as soon as we can prepare our filing, we will come in and get that before the commission.
Okay. As Atmos Energy is, I believe, one of the largest natural gas companies around, are you and other parts of your company were affected by Storm Uri? Is this securitization is this part of the plan with other entities?
Yes, so in Texas, we did file for securitization in I suppose it was early last summer. The legislature passed the securitization for the extraordinary gas costs in Texas. We made our filing at the end of July. And since then, the Texas Railroad Commission has reviewed that filing and has issued and has approved the moving forward of securitization on February 8th. And so at this time, we are just waiting for the bonds to be issued in Texas.
So the process is similar in both states, or would you say?
Yeah, pretty similar. The only difference in Texas is it was a statewide securitization. And so there will be one rate for the entire state of Texas.
Okay, thank you.
Mhm.
At this time, Chair Keen, I will hold my other questions. Thank you.
Very well. Thank you, Commissioner Duffy. Cross-examination, Commissioner French.
I have no questions for Ms. O'Connor. Thank you.
Thank you. And I have no questions either. Any further questions you would like to ask at this time, Commissioner Duffy?
I'll pass right now. Thank you.
All right, very, very well.
Yeah, Mr. Chairman, I do have just two redirect questions.
Just coming to you, Jim.
Okay,
Mr.
thank you.
Clark,
Very
redirect, please.
impatient this morning. So thank you. So Ms. O'Connor, the Commissioner Duffy asked you some questions about the timing on making the next filing if the commission approves the settlement in this case. And it's our intent, it's my understanding, I guess it's our intent that if the commission were to issue the order, let's say this month, that we're prepared to get that application filed very shortly after the order in this case. Is that right?
Yes, that's correct.
Yeah, I think the September date that Commissioner Duffy referenced, that was I think the date we were hoping to get approval of that next application that we would file. And then you also, Commissioner Duffy asked you some questions about the Texas process and the securitization bonds that were issued in Texas. Is it your understanding that the big difference in Texas and Kansas is that in Texas, the state is issuing the bonds, where in Kansas, the utilities are going to be issuing the bonds? Is that
Correct? Yes.
Okay. That's all I have. Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Flaherty. Mr. Connors, I believe that concludes your testimony, and you may virtually step down if you would. Thank you very much for appearing this morning. All right, we will move next to the curb witness. Mr. Love, would you please call your witness?
Yes, I would call Josh Franz and have him sworn in, please.
Naomi, if you would, please.
Yeah, Josh, I need you to raise your right hand so I can swear you in. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Good morning, Josh.
Good morning.
Could you please state your full name and your business address for the record?
Yes, my full name is Joshua P. Franz. My last name is spelled Frantz. I'm employed by the Citizens Utility Ratepayer Board, or CURB, which the business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
Are you the same Josh Franz that caused to be filed 17 pages of testimony in support of the unanimous settlement agreement dated February 24th of 2022?
Yeah, that's correct.
Do you have any changes you'd like to make to your testimony at this time?
No, thank you.
If I were to ask you similar questions today, would your answers be the same or similarly the same as to those you've already given?
Correct.
Commissioners, at this point, I would move that the testimony in support of the unanimous settlement agreement by Mr. Franz be admitted and spread upon the record, and I would tender him for any questions by the commission.
Very well. Is there any objection to the admission of his testimony? Hearing none, your pre-filed testimony is admitted. And good morning to you, Mr. Franz. We'll begin the commissioner cross-examination at this time with Commissioner French, please.
I also have no questions for Mr. Franz. Thank you.
All right, thank you. Commissioner Duffy.
Thank you. Yes, I do. Good morning, Mr. Franz. If you could please, you shared in your testimony that you had some concern about the 9.56 million of negotiated gas penalties. And if you could kind of share your concerns with me, I would appreciate that.
Sure, absolutely. And I appreciate the question. And I appreciate you kind of giving me an open forum here. So the first thing I will say is the settlement agreement in the 21-332 docket, which is the KGS docket, which is essentially the source of this penalty, or where you would track this penalty to originally. In that docket, the order was issued, I believe, yesterday or the day before. And so that penalty has been approved. And so, the first thing I would say, and something that I appreciate from the commission, and something that helps maybe alleviate some of my concern, is the fact that the commission very clearly expressed that decision is not precedential. And so, in that order, it basically says, it should not be assumed that the commission will waive penalties again. And I'm, maybe this is my opinion, but I'm just sort of extrapolating that, if there's a situation like this, really, any of the methodologies used, my understanding is that none of that is precedential. So that is one thing that helps alleviate some of my concern. But certainly because there's an order and that penalty has already been approved, I don't want to argue too hardly against that or anything along those regards. We're certainly supportive of that order. But just to explain the concern that I put forward, in that docket, there was essentially several marketers and transport customers, including Atmos, were short on their deliveries of gas. So Kansas Gas had to provide gas for those customers at prices that KGS used to get that gas instead of getting the gas, having the gas delivered to them from the marketers. So essentially, there was a non-unanimous agreement at one point. There was one party that was opposed. CURB and Atmos were both signatories to that first non-unanimous agreement. And in that agreement, the methodology was essentially a make-whole market price type argument or methodology for the calculation of those penalties. And as I said, CURB was supportive of that. We were a signatory, and so was Atmos. And then later, there was a unanimous agreement in order to get the objecting party on board. And as part of that unanimous agreement, the penalties for all customers, it wasn't necessarily a reduction across the board, but it was reduced for most customers based on a different methodology. And, as I mentioned in my testimony in this docket, that methodology, it included it factored in the gas purchased by KGS under its gas daily callable contracts. And so, in short, what that did was it reduced the penalty amount for Atmos. Unfortunately, I don't recall, and I was scrambling to find, but I couldn't find what the original penalty amount for Atmos would have been. But the amount that was approved and the amount that was agreed to in this docket was less. And essentially what my concern is, maybe a little more background here. So, and this, Mr. Grady, staff's witness, his testimony in support of the settlement agreement on page 32 and page 33, he does a good job really of laying out the details of what happened in this scenario specific to the penalty. So basically what happened was Southwest Energy is a supplier for Atmos, and Southwest Energy declared force majeure. And so they were not able to deliver sufficient quantities. And so, I'll make it clear, in no way do I think that this was a fault of Atmos. This was just, again, this event has several, interlocking pieces and several scenarios that are just, were not expected, really couldn't be planned for. And this is one of them, right? So, because of this force majeure, that really is I think Mr. Grady has listed that 88% of the volumes that Atmos was short were because of the Southwest Energy's force majeure. So, I mean, it's essentially, it's an upstream issue for Atmos. And so we're certainly, as I said before, CURB was supportive of the market price penalty. And even as Mr. Grady and Mr. Hendricks stated this morning, the reduced penalty from the unanimous settlement agreement that factors in some of those benefits that KGS had for its customers as far as the gas daily callables, that actually reduces the penalty for Atmos. And so, what Mr. Hendricks described as ironic, right? You've got Atmos whose penalties are less than they would have paid to through Southwest Energy if Southwest Energy had not declared force majeure. So essentially, Atmos benefited from Southwest Energy not being able to provide the energy. And that's great for Atmos customers. But CURB, we represent all residential ratepayer customers. As I said, we were a party in that KGS docket. And so, our concern here really is just that those penalties that get in the KGS docket, all of KGS's extraordinary costs will be securitized. And so, any reduction to a penalty to Atmos is going to essentially be borne by down the line by Kansas Gas sales customers. And so that's really our concern here, is just that, this sort of goes against that market price argument, which I think is sort of the most appropriate way to go about making these customers whole, and making the company whole with these failed deliveries. But one thing I'll add is we were not opposed to the unanimous settlement for other reasons. There were some benefits to that unanimous settlement, and so we took sort of a neutral position on that unanimous settlement agreement. And so I certainly didn't feel like it would be fair for us to be neutral there and then oppose this settlement. So, we supported this settlement, but just, I guess, for, fairness and to just sort of open discussion, I guess, we wanted to make our concern clear in both dockets, even though I certainly CURB is not opposed to the settlement in this docket. Hopefully that helps.
Yes, it does. Thank you, Mr. France, for kind of walking through that issue and explaining CURB's position. So let me look here. As it relates to the discussion, and it is in the settlement agreement about the company, Atmos will come back and discuss with staff, and I'm assuming CURB will be part of the discussion about low income rates. So apparently the company Atmos has programs in other states. Can you comment or share CURB's thoughts on this? This is also part of the KGS discussion as well.
Yeah, so this is a little complicated, and there is a difference between what KGS has agreed to and what Atmos has agreed to. KGS actually agreed to come forth with a low income rate. Atmos has agreed to essentially discuss low income programs, which is maybe not necessarily a low income rate or tariff. It might be something like energy efficiency for low income customers. So there is a very clear distinction there. And my understanding, I probably have to preface this by saying I'm not an attorney. My understanding is that there is a concern that from Atmos and possibly from other parties that a low income rate may not be allowable under law. And so CURB is behind the scenes, during this legislative session. And I don't know if it's going to happen this session, but we've certainly been working to put forward some maybe remedies or some suggestions or bills. This is not something that I've personally been working on. This is more our consumer counsel and another one of our analysts has been working on this. But generally, we are looking to maybe alleviate some of those concerns legislatively. And so I guess essentially that is my explanation for why the provision from Atmos is different from the provision for KGS. And that all has to do with the legality of a specific low income tariff as opposed to, low income programs. I mean, like Evergy has low income energy efficiency programs and they've applied for some more. And so I think clearly there's no legal issue there. That explains the difference.
Okay, I'm assuming that CURB will be front and center in the discussion of this.
Yeah, correct.
Okay.
I'm sure we'll follow up immediately after an order here, and kind of get down that path.
Okay, I'm aware that other states have programs. They're whether, like I'm looking right now at a bill from Wisconsin, from a community in Wisconsin, they have a statewide low income assistance fee that is charged. And then that goes to help folks on their bill beyond the LIHEAP programs and other things that are offered.
Yeah, I'm sure. And I mean, something like that is something that CURB would like to see or would like to have examined for Kansas. But again, I know that other parties have some legal concerns. And so, if we could get some legislation that maybe would make other parties more amenable to those kind of discussions, I think that's our focus, I guess, right now, and our sort of primary direction in this sphere of low income assistance. So, I think that's where we're directing our attention for now is on the legislative aspect.
Okay, because and I know that some folks, I live here in Topeka, and there are a lot of folks who are in very large old homes, not well insulated, still have the glass from the 1930s, and they're renting. And they're paying excessive bills because there's no requirements for energy efficiency within a lot of these homes.
Yeah, there's certainly no argument for me there. I mean, the issues that low income customers face are very diverse, and oftentimes you'll hear this idea that, well, if they're low income, they must have a smaller home, they must have less square footage, so it must be, but that's not true. I mean, there are all sorts of different factors, and every customer is unique, and so but certainly, I mean, programs like energy efficiency programs, I mean, those can help anyone. I mean, even someone who has a huge home and is wealthy, right? I mean, you can still reduce your bill through energy efficiency methods. So that's something that's kind of universally can be beneficial. And my understanding is that there's not as many legal hoops, I suppose, to get people on board for something like that.
Okay. Mr. France, can I also ask you, as we conclude this round of hearings, there's also going to be, what can we do to prevent this? Discussions, what can we do to prevent this, to improve our situation? And I'm assuming CURB will be part of that discussion, and perhaps you've even come up with a list of items as well.
Yeah, certainly. I mean, there's plenty of things that we're thinking through for every utility. I mean, this is, as you mentioned, this is not unique, and you're not unique to the Atmos process. Pretty much all of these dockets have become at least 2-tiered, if not 3-tiered. And so, yeah, that's something we're looking into. And as far as I know that, I mean, I'll just come forth with this because I know you've asked me about this in other dockets, the sort of plans to notify customers of what's coming. I've reached out to Kathleen, who was, the witness ahead of me. We talked briefly about setting up some meetings so that CURB can be involved in that process. And we've been involved with the other utilities about how they're going to get the message out to customers. It's a little more difficult with securitization because there's another process, right? As you brought up, right? These interest rates are changing, the markets are in flux, and so it's hard to give customers a real pinpointed bill impact when you don't know exactly how this is going to shake out. But certainly, we're going to initiate those talks real soon and kind of get on that. And it'll be, the most detailed information to customers is going to come once securitization is ironed out. We know what the bill impacts and stuff will be, but certainly, yeah, we plan to be involved with that as well.
Okay, thank you. I appreciate your response, and thank you, Mr. Chair, for the time, Commissioner King.
Thank you, Commissioner Duffy. Mr. Friends, I don't have any questions for you. So I would turn back to you, Mr. Love. Do you have any redirect?
I do not.
All right, very well.
Mr. Chairman, this is Jim Flaherty. Would I
Yes,
beg the commission's indulgence in asking Mr. Franz just one question based upon the commissioner's questions?
certainly.
Sir, thank you. So, good morning, Mr. Franz.
Morning.
So you had a discussion with Commissioner Duffy, and just so that I'm clear, when Atmos pays KGS the penalty that was approved by the commission yesterday, KGS then takes that penalty amount and uses that to reduce the amount that its customers will be paying for Storm Uri. And then once that happens, then KGS's customers will be made whole by that payment, correct?
Well, I think that's the general idea. I think we may have slight differences on what make whole means.
Means they're not out any money.
I think I would disagree with that statement, but again, that the order has already come out. That amount has been approved. I think the goal, it certainly was the goal, but CURB doesn't necessarily agree with the methodology that was used to come to those final amounts.
Okay, thank you. Thank you, Mr. Chairman.
Yes. Mr. Franz, I believe that concludes your testimony. You may virtually step down. Thank you.
Thank you.
All right, we'll move on. Mr. Hendricks, would you please call your witness?
Yes, at this time, we would call Justin T. Grady as the staff's witness.
Good morning.
Mr. Grady, I need to swear you in. If you'd raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Grady, will you state your name for the record, please?
Yeah, my name is Justin T. Grady.
And by whom are you employed?
I'm employed by the Kansas Corporation Commission.
And in what capacity?
I'm the Chief of Revenue Requirements, Cost of Service, and Finance.
In that capacity, have you caused to be prepared direct testimony and testimony in support of the settlement agreement?
Yes.
Have you filed a confidential version and a public redacted version?
Yes.
If the same questions were tendered to you today, would your answers be the same?
They would.
Do you have any corrections or changes that you would make in your pre-filed testimony?
No, not that I'm aware of.
Mr. Chairman, at this point, based on this preliminary examination, I would ask that Mr. Grady's confidential and public testimony be submitted to the record.
Is there any objection? Without objection, that testimony is admitted.
At this time, I would tender Mr. Grady for any commissioner questions that they may have.
All right, thank you, Mr. Hendricks. Cross-examination, I'll begin first this time with Commissioner French.
Thanks. Good morning, Justin.
Good morning, Commissioner.
I have limited questions for you because, I do want to thank you. Your testimony on the settlement was very comprehensive and detailed, and that was really helpful for my understanding. But maybe if I could just ask you to describe your approach to Atmos's situation as compared to the other LDCs in the state, Black Hills and KGS, and just describe, whether staff's approach was completely consistent. I understand they faced sort of differing fact patterns for each of the different utilities, but as far as staff's approach, could you describe how and whether it was consistent with the other utilities?
Yeah, sure. So it was consistent. If you were to look at we filed direct testimony and testimony in support of the settlement agreement, right? Because we didn't have an opportunity to file direct testimony prior to, it wasn't a traditional case in which, we all filed direct testimony, the company filed rebuttal, and then we settled the case. And so, there's sort of two sections to my testimony, and we wanted to be sure to be on the record for everybody, for customers, for the commissioners, just for purpose of the record, to say, the first half of my testimony is direct testimony, sort of our independent, unbiased evaluation of how Atmos did in its purchasing practices, how it responded to the event, and how its results that it achieved for its customers compared to the other gas utilities, right? So it's very similar, if not exactly the same level of analysis as we did for Black Hills and KGS as well. And like you said, it's remarkable how different and sort of nuanced between the three utilities their circumstances are. They are different. They all three have sort of different shades of gray and flavors of strategy with regard to how they purchase their gas and how they attempt to limit exposure to the daily physical gas market. But sort of remarkable, even though there are quite a few differences amongst the three major gas utilities, the results for their customers were quite similar. Of the three, KGS fared better than Black Hills or Atmos, especially once you account for the penalties that the commission approved yesterday. Once that gets accounted for, what KGS's sales customers are going to pay for gas on a per unit basis is going to be less than Black Hills or Atmos. But it's pretty remarkable when you compare Black Hills and Atmos and you look at what they ended up incurring during the event and you look at what they ended up incurring during the month for the month. They're remarkably similar between the two utilities. And even though they have different strategies, and maybe that's not a coincidence given the fact that they're both roughly the same size utility in Kansas, right? They both serve right around the same number of residential customers. So I mean, our evaluation was very, very similar amongst the three utilities.
Thanks, I appreciate that. Yeah, you can tell my concern is just getting confirmation that our approach and level of auditing and consumer protection is the same for all three utilities. So I appreciate your response. That is the only question I have for you, Mr. Grady. Thank you.
Thank you.
Cross-examination, Commissioner Duffy.
Thank you very much. I'm going to lead off with the securitization as I did with Kathleen. So as we go forward, are you concerned? I mean, I know staff has their pulse on what's going on in the bond market and just the overall economy. Do you have concern that the Securitization Act that was passed by the legislature will be as successful come September or whenever we actually move on it or they move on it as we anticipated, 6 months ago?
Yeah, so I guess what I would offer is that, there is a lot of flux, there's a lot of turmoil or flux in the financial markets right now, right? We've got inflation concerns that are leading to higher interest rates. But on the other hand, the events of the last 7 or 8 days have actually led to a decline in interest rates in the United States pretty significantly, right? I was looking just about 10 minutes ago. The 10-year Treasury rate is down to 1.7% right now. That's a 30 basis point move since the Ukraine invasion, right? So you have sort of a twist of fate, but when there's significant world instability or concern, the United States government and Treasury rates are the safest investment in the world, even if they're only providing 1.7% return for 10 years. So that flight to safety is sort of pushing against any concern about inflation and the Federal Reserve raising interest rates right now. So how long that's going to last, who knows, right? It's obviously a concern. The longer that we wait, and the longer that there's a delay in the issuance of those securitized bonds, then there certainly is the potential that those interest rates will be higher. But there's no guarantee. I can't predict the future with regard to where interest rates will be. If we wait longer, then there's a possibility the rates would have otherwise been lower, right? There's no certainty in that regard. But the one thing that I would offer that should be some consolation is that if interest rates are 1 percentage point higher, 6 months from now, and the securitized bonds are issued at 3% instead of 2%, then the utility's underlying cost of borrowing is going to be even higher than 1% higher, right? Securitized bonds will always be the lowest cost of financing that exists in the utility's financial portfolio. So, so the relative benefit of securitization is not going to go away, even if the absolute, nominal rate impact is a little bit higher.
So it does sound like time is of the essence, though. When I hear the Fed saying they're going to go in and raise interest rates maybe 6 times during the year, you begin to wonder then at what point does it impact the bonds. So would you agree that time is important here?
I do.
Okay. All right. Thank you. The discussion offered by Mr. Franz on the $9.5 million worth of penalties. All right. He explained it from his standpoint. Do you want to offer any other additional information to that explanation, or shed a little bit different light if you could?
Sure. Thanks for the opportunity. Yeah. So Mr. France and I have a disagreement about this. I think the key distinction, the most impactful disagreement that we have is the method of calculating the negotiated gas cost penalties that the commission approved yesterday, right? And I understand why, why Mr. France put the sentence or two in his testimony that he did about their reservations regarding how those costs were calculated. But I do disagree with the the conclusion or the assertion that's in that testimony. What this really rests on is, this is just an honest difference of opinion, but Mr. France's view is that the marketers and transportation customers, Atmos, of whom is one, should have been billed all of the spot price gas, should have taken up all of the deficiencies in gas that KGS had to purchase in order to make up for the deficiencies, should have first been assigned spot price gas prices. And then after that, the gas daily callable gas would have filled in, the gaps. That is the only difference between the original non-unanimous settlement and the unanimous settlement for Atmos, right? That's the only difference. And the reason I ultimately we disagreed about that, and the reason we changed the methodology, was the fact that we became convinced, 100% convinced, that KGS wasn't only relying on the spot market to fulfill those deficiencies during that period of time. I mean, you can disagree with the theory or the appropriateness of sort of cutting them that break compared to the spot purchases, the spot market. But the evidence in that docket supports the fact that KGS was using both gas daily callable gas and spot market gas to make up the deficiencies. And that's the key. And that is what we charged Atmos and Evergy and Sunflower and every other marketer in that KGS docket. And so what I disagree with is the idea that somehow KGS's sales customers aren't, quote, being made whole. I don't agree with that. I think they are being made whole. The only amount that KGS's sales customers weren't appropriately made whole to was the $6 million discount that was given to Symmetry in that settlement agreement. And the rationale for that was, explained in my testimony, and I thought the order did a good job of picking that up as well. But we just have a difference of opinion with regard to, whether the penalty, the negotiated gas cost penalty, should have been more reflective of a market, rate or a market spot market type of a signal price. But at the end of the day, what KGS and its sales customers paid for that gas during this period of time, Atmos is now reimbursing them for. And, that's my position. I think that's what the evidence that's what the evidence supports.
And how will that reimbursement be made? Is that in one payment? Remind me, or is that spread over a period of time?
It is one payment. I think it's within 45 days of the commission order. So there's only one other thing I want to mention with regard to, the thing that's a little, and I mentioned this in my testimony, but I have a little bit additional information that I could provide too that I think is helpful, is that, it is somewhat concerning when you have a regulated utility that is, contributing to, or especially if they were exacerbating supply shortages on the KGS system, right? That's concerning. And I think that also feeds into some of CURB's original concerns with regard to the idea that Atmos was going to be allowed to pass this penalty on to its customers. So, you know, I put some of this in my testimony, but I looked this morning to see how these supply shortages compared to the total amount of gas that Atmos delivered during this period of time. And what I mentioned in my testimony is I said, look, everybody had shortages, everybody had force majeure cuts. This happened across the state of Kansas. This isn't anything that was unusual to Atmos, right? But I actually calculated this morning how these supply shortages that Atmos experienced relative to the total gas that they just delivered during this period of time. I calculated how that compared to KGS's supply cuts and what they experienced during this period of time, right? Because I thought this might come up. So Atmos had almost 37,000 decatherms of supply shortage on KGS's system, right? That was 1.8% of the total gas that they delivered from February 9th through February 22nd. Okay. I looked at KGS's supply cuts this morning. I added it up. KGS had 357,000 decatherms of gas that was cut by its suppliers during that same time frame. Okay. And that is out of 8.5 BCF of gas, or 8.5 million decatherms, which is 4.2% of the total that they delivered during that period of time. So I agree that it's concerning, right? That you have a regulated utility contributing to another regulated utility's supply shortages, but Atmos did a really good job of securing gas supplies during this storm, right? 1.8% of their gas was cut, and that's less than half of what KGS's actual supply cuts were on its system. So, you know, hopefully that puts it into perspective. I think Atmos, they didn't do this on purpose. It was one supplier that declared force majeure, and it ended up being a benefit to their customers. But I disagree that it was actually a cost to KGS.
Okay. I do think that explanation from Curb and from staff is important to have on the record, because it is the kind of anomaly that showed up in testimony, and I think it needed to be vented and shared here with commissioners in this forum. So I appreciate the parties speaking to that. Justin, as we look forward, and we're going to be meeting, or staff is going to be meeting with, how do we do better next time? And what can we do to ensure that our fortress, we have a fortress against this in the future? Is that something we're working on right now? Because we're coming at the end of a winter. It's been cold, but we haven't had any devastating temperatures long-term like we did last year. But will we be prepared, better prepared for the next winter? What is your time frame here, and how do you see this part unfolding?
Sure. So, so all of the three major gas utilities made changes to their gas purchase supply plans and their hedging practices for the winter that we're in right now, right? The winter season for a gas utility doesn't actually end until the end of March, right? Or at least that's the time period that we look at. I mean, the gas utilities all experienced significantly higher market prices, storage gas cost, baseload gas, first of the month gas, et cetera, this year compared to last year. That's not a surprise to anybody on this call. But if the daily physical gas market would have experienced, significant price volatility this February, for instance, as was the case last year, then we would not have experienced the same devastating financial impacts in Kansas. I mean, so each gas utility was a little, so the degree of protection that each gas utility could afford relative to its existing commission approved budgets was a little bit different. And, these gas utilities are just different. They have differing amounts of exposure to interstate gas pipelines. And depending on your exposure to different interstate gas pipelines, your risk profile is different. And so, I unfortunately, I can't report that that every gas utility in the state will be protected from the financial impact of a repeat of Winter Storm Uri. If that were to occur next winter, God forbid, then there will be financial impacts. There would be financial impacts that gas utilities incurred or experienced, but it will be substantially mitigated. The difficult thing about trying to protect yourself entirely from the daily physical gas market is that it's very expensive to do that, right? It's very expensive to do that, or you have to sign up today for fixed price gas price next winter. And, gas utilities can do that. Those are the sort of conversations we're having. And I know that the gas utilities themselves, the purchasing managers and the gas supply departments are evaluating these sort of things, probably as we speak. But you're never gonna get it right to the point where you make everybody happy. We're either we could order the gas utilities right now to sign up for fixed price gas for all of next winter, and that would probably cost them $5 or $6 an MMBTU, which would be around 3 times the market price for last year. We could do that, and then if the gas price falls to $3, then 80% of people in the state are going to think that we're idiots and we made a terrible decision. On the other hand, there's financial market hedges that you can accumulate, that you can acquire, and because of the amount of insurance that those provide, those are pretty expensive as well. So there just are no easy answers. As far as what our timeline is, we're working through those issues with the gas utilities as they come in. I don't know whether we will, because each of the 3 gas utilities can't know what the other 3 gas utilities are doing precisely because it's a competitive market. I don't think we're going to have like one overarching commission decision that pertains to all of the gas utilities and provides all of the protection, in order to prevent a Winter Storm Uri, the next occurrence. I think what will happen is we will file, the next steps in each of these individual dockets is we will file a report and recommendation that sort of, similar to what we filed in the Evergy docket recently, that's sort of all encompassing, that says, look, here are our findings with regard to operationally, your customer communications, here are recommendations on tariff review or tariff revisions. Basically, it's our comprehensive evaluation of how the utility performed during Uri and whether there are any recommendations for the future. With With regard to the gas purchasing and hedging practices, though, a lot of those changes have already occurred in the individual gas purchase and hedging dockets. So, yeah, so I know that was not a real well organized response, but those are sort of all of the things that we're working on.
I appreciate the update. Two more things. Do you see any movement at the national level for any of the adjustments they need to make as it relates to the gas markets? And from, there were a lot of complaints that, wow, this happened on a holiday too, and you couldn't do anything, and that there were just some issues at that level. Are you seeing any progress being made to adjustments to improve the system?
I don't think so, unfortunately. I mean, there are discussions that are occurring at NASB, which, geez, I'm not sure I can remember what that stands for right now. National Association of Energy Standards Board. I'm not sure if that's right. Jim will know, but there are discussions pertaining to the force majeure clauses that were exercised during this event. I know, there's a process where SPP is going to attempt to be more involved in some of those NASB discussions, and there's a potential for some reform of the force majeure language that are in those contracts. But other than that, I don't know of any concerted effort to change the industry with regard to the gas day, or with regard to the fact that when financial markets are closed, organized exchanges of commodity and organized commodity markets and organized trading of commodities like natural gas are also closed, right? So this was obviously such a perfect storm when you had the coldest days and the highest demanded days were in the middle of a 4-day weekend in which financial markets were closed. That certainly exacerbated it. But yeah, I know that there is a FERC docket open on the transparency and the effectiveness of price indexes, but I don't think that there has been any movement in the last 6 months that's been public. I mean, we're not, directly part of that investigation. So I don't know if there are any national reforms, honestly, that are underway that would improve this situation. Most of our efforts and attention, and I know the utilities that we deal with, it's been more of how can we change our contracts? How can we change our strategies to be less exposed to any one pipeline? More diversity with regard to the types of gas that we contract for, price caps on our daily call contracts. Diversifying our use of and source of storage. It's all of those kind of things to sort of deal with the risks that now have been exposed as being very realized as in the natural gas market. That's what people are trying to do.
Okay, so as you've kind of touched on this, do you have any updates or know of anything in terms of the investigations going on at the Attorney General level into any profiteering, malfeasance, that sort of thing? Have you been apprised of any activity, action?
No, I don't have any updates.
Thank you, Mr. Chairman. Those are all my questions. And thank you, Mr. Grady. And I would concur with my fellow commissioner. I do appreciate the breadth and depth of your testimony on the settlement agreement. The work that you put into that to express the very nature of the agreement. So thank you.
Thank you.
All right, thank you, Commissioner Duffy. Good morning, Justin.
Good morning, Chair.
For the benefit of this morning's record, I want to briefly summarize with you and see if we can come to some understanding of your overview and the conclusions that you've reached that are contained within your pre-filed testimony and your testimony this morning, at least as I understand it. And if I'm incorrect on any of these things, I would encourage you to correct. First, as I understand your testimony, the plan presented by Atmos in this docket allows sales customers to pay for the extraordinary costs associated with this Winter Storm Uri over a period of time that is going to be commensurate with a financing order that will be filed under, prospectively, under the Utility Financing and Securities Act. Is that correct?
That's correct.
Second, as I understand your testimony, while these charges will be a hardship for many of Atmos's customers, it's going to be a less hardship than it would have been to pay for these costs through the normal course of business via the purchase gas adjustment clause, which essentially, as I understand it, would have called for paying these costs over a one-year period. Is that correct?
Yes. Yes, sir. That's right.
Third, the plan presented by Atmos, as I understand it, recognizes that there are real costs associated with allowing customers to pay off balances over an extended period of time. And the plan allows for the recovery of these carrying costs under the settlement agreement at a 2% annual rate. Although Atmos's original plan included carrying charges of 8.396%. That plan was modified by the terms of the settlement agreement to limit the carrying cost to 2% through the period through which there are securitized bonds issued. Is that correct?
Yes.
And fourth, in addition to the staff's review of the reasonableness of the financial plan, I think the staff has reviewed the reasonableness and prudence of the Atmos gas purchase gas cost, incurred during Winter Storm Uri. And that review indicates, does it not, that the Atmos gas purchases during February of 2021 were consistent with the gas purchase and hedging plan that the utility has filed and files on an annual basis with the commission. Is that correct?
Yes.
I'm almost done. I think it's helpful to go through this review with you as the key staff witness here. I think it's important for the benefit of the public to understand some of these overview considerations. Fifth, and I think you've indicated this, that Atmos's hedging and gas purchase plan was not able to completely insulate the utility or its customers from the extremely volatile daily natural gas price fluctuations that occurred during Winter Storm Uri. The balanced nature of its reliance on baseload purchases priced at first of month prices, as well as swing gas prices at the gas daily index prices, resulted in their paying a weighted average cost of approximately $66 per MMBTU for purchased gas during the February 9th through the February 21st time period, which was approximately $45.82 per MMBTU lower than the average market price of $111.82 per MMBTU during this same time frame. Is that recollection correct?
Yes. Yes, sir.
Okay. So in essence, what I see here, staff has reviewed the financial plan that Atmos has filed in this docket as modified by the settlement agreement. And as I understand it, the staff is contending that it's a reasonable and balanced plan that will appropriately, minimize the financial effects to sales customers of the extraordinary gas costs Atmos incurred during Winter Storm Uri, while simultaneously allowing Atmos to maintain its financial integrity and recover the necessary costs associated with these carrying these extraordinary costs through the issuance of securitized utility tariff bonds. Is that correct?
Yes, sir.
Okay. Let me really cut to the chase then and ask you my final three questions. And these questions are by way of summary again, and they pertain to, I think, my questions of you about your overall assessment of the settlement agreement. With regard to the settlement agreement, in your opinion, is it supported by substantially competent evidence?
Yes, sir. I believe it is.
With regard to the settlement agreement, will it result in just and equitable rates or charges?
Yes, I believe it will.
And third, with regard to the settlement agreement, in your opinion, is it in the public interest?
Yes. Yes, I believe it is in the public interest.
My final question to you, Justin, is this, and I'm going to give you some license and leeway to address this in any way that you would prefer. Do you have any additional matters that you would care or wish to elaborate on or explain for the record by way of conclusions or overview perspectives that you have coming away from this particular docket?
Well, nothing, particularly brilliant. I just with Atmos, as has been said in some of the previous hearings, there isn't anything. I don't know. It's essentially what this settlement does is take a really unfortunate and crummy situation and try to reduce the impact of it as much as we can for customers. And the securitization, the ability to use the securitization statute will help a lot in that regard. Ultimately, I think these costs will end up being securitized over something like 7 to 10 years, and probably not more than that, or at least that's my my hope or my view. The financing costs that the securitization statute and the securitization process should unlock will be the lowest financing costs that the utility has at its disposal, even if interest rates increase, between now and when those bonds are issued. And so, I know it's not quite the same, but this morning I was thinking about, my personal access to capital. And if I have an unplanned vehicle, repair or home improvement project that I have to come up, raise capital, I was thinking to myself, well, what would my source of capital be? Well, my source of capital would probably be my home equity line of credit. And that's, something like 4% cost of capital. And, this is essentially, it's Mr. Flaherty said it, it's for almost every gas utility in the state. It was between $500 and $700 worth of gas per residential customer that was incurred over a 10-day period of time. And this is, it's it's an extremely unfortunate event that there was a large unplanned family home expenditure that was dropped on Kansans. And this allows people to access capital at 2% to pay this off over, over an extended period of time, so that hopefully it doesn't cause an unfortunate, impact or more of an impact on people's personal finances. And so I don't know how much that helps, but that's about the best that we could do in this circumstance. And so, that's what the settlement accomplishes.
Thank you very much for that overview. I appreciate so much your perspective. I think we could all come up with an adjective to describe the events of about a year ago in Winter Storm Uri. Certainly, crummy is one way to do it. I think we could probably come up with some that would be more colorful and descriptive of that. But nevertheless, God willing, we will not have to experience anything like that again. That concludes all of my questions, Justin. I appreciate very much your answers. Commissioner Duffy, any further questions?
Yes, while we're talking about capital, in virtually all the dockets we've had to deal with, the companies have come in with a weighted average cost of capital, and here with Atmos, it was 8.396%. And it seemed like the first order of business was to get that reduced, again, in all cases, to 2%. So this weighted average cost of capital of 8.3, was that really realistic? I mean, should that, seriously be considered when we're looking at this situation?
Well, that's a good question. So the precedent that we have, the problem is this is such an unprecedented situation, right? And so, especially in the time frame in which these decisions were made, as you're aware, the commission's emergency order was written over the weekend and approved first thing on Monday morning literally during the middle of this crisis. And so, I think the commission's order, what it did is it put a stake in the ground, right, during a time period in which we literally were observing people freezing to death in some states. And it said, we realize there's extraordinary market disruptions and extreme prices, and we realize there are gas utilities in the state that are not able to, there's margin calls occurring, and there are people that are not able to afford their gas purchases and their purchase power. And we are hereby ordering you to take all necessary steps to continue reliable service to your customers. And, there was a real concern. There was so much uncertainty as to at what the financial market reactions and response would be. We had utilities, Atmos is no different, Kansas Gas Service, these companies were incurring, it'd be like Evergy incurring $15 billion worth of long-term debt overnight, over the weekend. These companies were a going concern for a few hours or a few days probably. And so, the commission was trying to, I think, being appropriately risk averse, and was saying, look, sending a signal to the financial markets and to these utilities that you need to do everything necessary to keep Kansas customers safe. And we will have a process to allow you to recover your costs. And the only precedent that the commission really had to look to in terms of accounting authority orders, if there's a devastating tornado or there's an ice storm that takes out half of the utility system, the way we compensate both utility customers and utility for deferred cost recovery in rate making is with the weighted average cost of capital. And so I think appropriately the commission's first concern was, to the extent the financial markets are worried that they're not going to, that we're not going to allow these utilities to recover these costs, or that they're going to have carrying charges that won't be reimbursed. It was an overly cautious move, probably, to ensure that the gas utilities could continue to provide service. And then, as the details, as time passed, and as we realized that, these utilities maintained access to the capital markets, they did have downgrades in their credit ratings, but ultimately their borrowing costs stayed reasonable. They were able to pay back their suppliers, and it became, we had more information. And then as we had more information, it became clear that we probably don't have to compensate these companies at the weighted average cost of capital, especially if they're going to use securitization, right? Because now it became clear that they're only going to carry these balances for maybe a year, maybe 18 months. And so now you can use shorter term capital. The utilities were able to roll over that use of extremely short-term emergency financing, and they rolled it over into term financing. And so now we knew exactly what the cost was, and we could reimburse the utilities for their actual costs with a minor cushion to account for variable interest rates. And so, that's what you saw. That's what you're seeing. It's the passage of time and the fact that information becomes clearer over time, and decision-making can become, more informative and more informed and more precise. That's the way I would view, the progression of weighted average cost of capital to eventually the 2%.
Okay, thank you for that explanation. That I think is another piece of the pie, so I appreciate that. Thank you, Mr. Chairman.
Thank you, Commissioner Duffy. Mr. Hendricks, redirect.
Mr. Chairman, I will spare you any redirect, and I will conclude.
Okay, very well. Thank you. Mr. Grady, I believe this concludes your testimony. You may virtually step down. We thank you.
Thank you.
I believe that this concludes our hearing on the unanimous settlement agreement regarding Atmos Energy Corporation's financial plan in docket number 21-ATMG-333-GIG. As a reminder, a commission order in this docket is due by March 24th, 2022. If there are no further matters, we will stand adjourned. And I thank all for your participation this morning. Be safe.
Take care.
Thank you.